Members of the jury, we're almost there. Mr. McClimate told you that this gang war in Jacksonville is tragic. That's the only thing that I think that the state is in agreement with what he just argued to you. It is very tragic, the killing on both sides that happened, and the law places a high regard for the sanctity and the protection of human life. And the law protects everyone equally. It doesn't matter who the victim is, and it doesn't matter what the victim does for a living. If you purposely intend to commit first-degree premeditated murder and kill a person, regardless who that person is, and we have proven all of those elements, the law requires that that person be convicted. And when you talk about the standard of proof, proof beyond a reasonable doubt, that is what you have in this case, and you have higher than that. The defense attorney has asked or suggested to you, where is the DNA? Where is the fingerprints? All of that type of evidence is to establish one thing: who is the perpetrator? When there is a killer and there is no evidence, there is no eyewitness, and there is no videotape, then the law allows us to present evidence, direct evidence, and circumstantial evidence to you to establish and prove the identity of the perpetrator. Somebody broke into a house and shot and killed a person, and nobody saw it, and that person broke a window to get in and left their blood on that window, that could be used to establish what? The identity of the perpetrator. If they weren't wearing gloves and they touched that window and the law enforcement officers dusted for prints, they would send it off. It is very, very rare when you capture the entire crime on video. This age of digital technology proves beyond all reasonable doubt what happened in this case. You don't need an eyewitness to come in here and tell you what happened to Charles Jones on June 23rd of 2024. You don't need a fingerprint analyst to come in here and tell you who killed Charles Jones on that date. And you certainly don't need a DNA analyst because you saw it. His murder is captured on video. There are 2 cars involved, and you saw what happened at each and every location. We don't have to present DNA evidence to you. We don't have to present fingerprint evidence to you. Law enforcement officers didn't need to submit any sort of DNA to the labs to figure out what happened in this case. Because of digital evidence and video evidence, you know everything that happened to that victim. He was hunted. He was stalked. He was hunted at teasers. He was stalked, and then he went to a second location, to Truth 18, and he was followed, and he was hunted, and he was stalked. And you saw both of the vehicles that are involved in this case. And she is in the silver Chevy Cruze. There is no doubt about that. We don't have to fingerprint the silver Chevy Cruze. We don't have to dust it or swab it for DNA to know that she is in that car with her boyfriend. You saw that silver Chevy Cruze. You saw it at teasers, following, going, parking, and then the 2 of them get out to get in eyesight of the victim. All of that is clear. What is also clear is she is not going up to the club. She's not going clubbing. Neither is her boyfriend. It is for one purpose: to stalk the victim, Charles Jones, in this case. And at the second scene, all of that is on video as well. You see the parking lot of that location. You see it with your own eyes. And there is no doubt who every single individual is in both of those cars. We have proven it beyond and to the exclusion of all reasonable doubt. And you saw it at the Home to Suites video. You saw it at the USF poll cam. That victim is followed. And you saw those text messages from Sean Gathright to Kayla Enright. They want to know where Julio is, where 6 is. And in those messages to Kayla Enright, you know that they are watching him. You know, and you saw what Charles Jones is doing that night. He's on Instagram. When Sean Gathright contacts Kayla Enright, they say what? We're looking for 6. He's in Tampa. He's at an Airbnb. You saw his Instagram story. He's posting live. He's at an Airbnb. The only location that they weren't aware of that wasn't planned is this pool party at the Airbnb. Defense has suggested to you, Kayla Enright, she's not charged. No, she's not. There is a law, the law of principle, that shows that we have to prove that the person who assists, the person who is a principal, intended the crime to be committed and did something to assist. Kayla Enright is in no way in the same position as this defendant. She is not in a vehicle with all of the perpetrators. She is not stalking the victim. She is not in Tampa. There isn't any evidence other than a message to her while she's in another location to contact someone to find 6. To suggest to you that any of the girls or young women in the victim's party is in the same position of her is preposterous. Nobody in the victim's party is doing anything but celebrating a birthday party. When you talk about beyond and to the exclusion of all reasonable doubt, to suggest to you that evidence from the defendant's phone only 3 years before this homicide has been committed, of where she says the victim in this case that she hopes he dies, to suggest to you that that isn't relevant to intent. This is a homicide case where she is charged with first-degree murder of Charles Jones, of Julio, where she is charged with conspiracy to commit first-degree murder. To suggest to you a message to a friend where she specifically says, I hope Julio dies, is not important critical evidence for you to hear. To suggest to you that the attempted murder of a victim that occurred only months before his actual murder, that connects them to that, is not evidence of first-degree murder. It absolutely is. The killers didn't get him in October. The rifle that was used to shoot him, that shot that projectile, that shot him in the foot, a casing was recovered from that scene. The fact that that is connected to the homicide to kill the exact same victim is absolute evidence of intent. It is the most powerful type of evidence of intent that could possibly come before you. When we talk about her phone evidence, when we talk about what we have to show to prove that she had the knowledge and the requisite intent, that is why we brought that phone evidence to you. Because there's no doubt of what happened to this victim. There's absolutely no doubt of how he was stalked. And I think the defense attorney said and talked about Rashad Murphy and Davan Murphy about how they would not allow her to know what was going on. What I can make an argument about that and submit to you is that I do agree with that. There is no way that people who are going to commit first-degree premeditated murder would allow anybody into their inner circle unless they were absolutely trusted, that they absolutely trusted that person 100%, that that person is ride or die, because all of them can be identified if law enforcement finds out. And she absolutely proves that that's exactly what she is, because when faced with law enforcement, when faced with telling her that you could be charged, that you will be charged with first-degree premeditated murder, she would not give any of them up. She would not give a name. She would not give a description, because she did not want to implicate any of them. And when we talk about consciousness of guilt, that is evidence. Just like circumstantial evidence, all of that is considered evidence in a case. There's not going to be anything in these instructions that define for you what direct evidence is, what circumstantial evidence is, or what consciousness of guilt evidence is. But all of the evidence that is presented to you can be evaluated by you to determine whether or not the defendant is guilty or not guilty. And she is not innocent. The evidence in this case proves overwhelmingly that she lied to law enforcement. And that evading of law enforcement, that lying to them, shows that she has something to hide. Innocent people don't have to lie to law enforcement. Innocent people are cooperative and tell what they know when somebody has been killed in cold blood. And that is what has happened in this case. Charles Jones was hunted and he was tracked down and he was killed. And to suggest to you that she was not a trusted member of this group, of this conspiracy, flies in the face of all of the evidence. We rely on you to use your common sense when you evaluate this evidence, and when you look at what is on her phone, and when you see the personal animosity and what she was living in at the time when she wrote those messages. The one message that isn't in evidence, when I asked her about Antonio Tilley and the person who died the day before Charles Jones is shot in the foot. Remember that? I refreshed her recollection.
Well, you need to link it up to evidence they did here, okay?
You heard her testimony. I questioned her on her conversations with Isaiah Chance, her co-defendant, her boyfriend, the person that she continues to protect again and again and again. I questioned her about the communication she specifically had with him in 2023, not 3 years before this homicide, less than a year before this homicide. And she claims she knows nothing about the gang stuff. She knows nothing that is going on. There is more than one conversation with her and Isaiah Chance about what is going on in this gang war and who has been killed, personal in their lives. One you saw in evidence, the town center, where it is clear they have talked about it before, because her response when she realized it's about the town center and that 23 has been killed there, she says, I forgot. I'm sorry, we don't have to go there. That conversation is in evidence. You also have testimony from her on the stand specifically about the death of her boyfriend's good friend, Antonio Tilley, that occurred on October 6th, the early morning hours going into October 7th of 2023, where I specifically asked her on the stand, you've talked to him about that. Oh, I can't really remember. So we refreshed her recollection. It's not in evidence, but we refreshed her recollection with the conversation. All of a sudden, she remembers it, right? That's what she does. She doesn't remember it until she's faced with hard evidence. She sees that conversation, and now she's got to answer questions about it, right? And what is it about? It is about another person close to her boyfriend that has died in this gang war. It's about Antonio Tilley, Tilley's death. He is upset about it. And before I can even get a question out, she says, oh, yep, he didn't want me to be around him at that moment. He was so upset, he didn't want me to be around. He needed to be by himself. And then there's another conversation on October 8th, the very next day, where he has done something and they have talked about it. And he needs her to be loyal. She remembers that, right? She would have you believe, now that we've confronted her with that evidence, that he wants her to be loyal and that she needed to delete that conversation that they had texted about, that's about her cheating again. The same boyfriend that she has testified to you about domestic violence, that she's afraid of him. Now you hear that she's worried about him and that he needs her to be loyal and that he's confided something to her on that day. That is the day that Charles Jones is shot in the foot. That is the crime that also is connected to this case and evidence of all of the perpetrators' intent. They tried to kill him in October and failed. They were successful here in Tampa on June 23rd of 2023. That is why that evidence is so important. Conspiracies to commit first-degree murder don't happen in front of eyewitnesses. They don't happen in the light of day. They happen in dark places where people know that it is a crime and they know what they're doing and they want to get away with it. Actions speak louder than words. The defendant is never going to come in here and admit to being involved in a conspiracy to commit first-degree murder. Defendant is never going to be admitting to anyone, to law enforcement, or on the stand about her knowledge, to agreeing to be a principal to first-degree premeditated murder. But the law allows us to show you all of the evidence that can show what it is she intended. And that is why you saw those photographs from her phone. Nobody from the state side ever suggested to you that she is a gang queen pin. Nobody has suggested to you through law enforcement, to any witness the state put up with law enforcement that is an expert in this gang war in Jacksonville. They have all said the same thing. She is not in a gang. She is not charged with being in a gang. Why is all of that relevant? Because, again, to law enforcement, she lied about it. She lied about knowing anything about the gang. She wants them to believe that she has no knowledge. She wants them to believe that she doesn't even know about her boyfriend's nickname, Gutta. And you all know, again, the evidence is overwhelming that that is a lie. Not only does she call him Gutta, not only does she know that that's his nickname, not only does she know that is his gang stage name for his own drill rap videos, she has it tattooed on her twice. That's the reason why those photographs are relevant. It again shows her lying to law enforcement. The reason that you saw all of those messages to other people in the gang about the gangs, there's conversations about Bibby and Robert Howard, gang member after gang member. That corresponding message to Jewel Jordan, we brought that to you. That's a good friend of hers. You think she wanted to testify against her friend? You have to evaluate each and every piece of evidence and what it shows and what it proves. It proves that she knew exactly what was going on in this gang war. It proves that she personally knew people that were affected by this gang war. When you look at the phone evidence, I know that there is a lot in there. The defense attorney argued to you that there is no text messaging of her or Instagram of her from her phone. That is because she got rid of her phone. You heard from not only our expert, but their expert, some of this information is not backed up. Some of this information you can only get if you have the device itself. That text messaging that we have between her phone and Sean Gathwright's phone during the time of the crime, that was only retrieved by Sean Gathwright's phone. Her phone didn't have those same messages. Her phone is backed up, and her phone had photographs on it. Her phone had conversations on it, but the time period you heard from Detective Ramos where they were looking at that time period for the crime was not on the Apple iCloud backup. And there's two ways that can happen. It can happen either by it not being something that she backs up, or it can happen if a person personally gets rid of that time period and deletes it from their phone. We never got her phone. You heard that others got rid of their phone. Sean Gathwright, who was using his phone in this instance. So it wasn't just her that got rid of her phone. Sean Gathwright got rid of his phone as well. And again, more evidence of her intent is the conversation when she knows law enforcement is looking for her. That's why we presented all of that information from the phones to all of you. Because again, it is evidence of her intent that something is on her phone that she does not want law enforcement to know about. That is the reason she's laughing her, LMFAO. That is why she is laughing out loud, because law enforcement got her new phone. And in the middle of this search warrant, when law enforcement is executing it, she has a new phone that she is trying to back up all the stuff from the iCloud. She got rid of her device, and she got rid of the specific text messages that surround that time period. If you look at those videos where her boyfriend, Isaiah Chance, is walking around with her phone, it's not just up to her ear. Look at it. He has it out like this. That is a way a person holds a phone when they are speaking on speakerphone. There are conversations happening, and there are calls that are being made and communicated between him and the shooter's vehicle. And they keep on suggesting to you that the call, the attempted call that is in the call detail records, happened when he is out in that parking lot in Teasers. That is not. If you look at the timing, both by our expert and the defense expert, the timing is clear. That's why we went through so much trouble about making sure the timestamp is accurate at each and every video that you heard. And when you look at the call detail records, the calls that are reflected on the call detail records of her phone show that she is already in her car with the defendant when those calls are being made. What is not captured, what is an unauthorized app that they are using when she needs to put in her passcode, is not captured because they are using another app to make those phone calls.
Your Honor, I'm going to object at this time. Can we go sidebar?
Yes?
So going back to the phone, there is clearly phone communication that is being used that is not captured in the call detail records, and the timing is important because, again, there is communication going on with the vehicle that has the assault team in it, and that is not something that they want tracked. The other piece of evidence that is important that she says to law enforcement in that interview is that she has to enter her passcode. Her phone is protected. She has a passcode that she has to put in there, and that is something that happens automatically. Anybody who has an iPhone that has a password or has to get into their phone by their face knows that that is something that happens automatically. When you have a phone, it goes dark and you have to put in your passcode. That is what is happening there. She is still using her phone. She uses her phone all the time, and she is allowing her boyfriend to use her phone, and when it goes dark, she has to put in the passcode for him. She knows what is being said on that phone to that second vehicle. There is no way that she did not hear what was going on. There is no way that she did not know everything that was planned to occur in Tampa. This whole story about teasers, and now to make it, I guess, that she didn't lie to law enforcement this one time about the bouncers, they're saying that that was about that was about the Players Club. That makes it even a worse story, because now it isn't that she didn't get to go to 2 clubs, now it's that she didn't get to go to 3 clubs. All 3 clubs were either too packed, overpriced. Is it based on it's too packed based on the parking lot and the amount of cars in the parking lot? If that were really the truth, then they never would have had to get out of their vehicles. But again, that crime is on video. And you know the only time they get out of their vehicle, that is to see if the victim is at that location, at Teasers, at Truth 18. That is why they are there. The defense attorney talked to you a little bit about the jury instructions. He talked about murder in the 2nd degree, and so I just want to touch briefly upon it. There is another instruction that you will hear from the judge, and that is that you should find the defendant guilty of the highest crime that has been proven beyond and to the exclusion of all reasonable doubt. And the top count for count 1 is 1st degree premeditated murder. And principle applies to this. Principle also applies to murder in the 2nd degree. But this case, murder in the 1st degree, is the top count, and all of these elements have been proven at beyond and to the exclusion of all reasonable doubt. And the reason why I'm putting this back up is because the death, count 2, if you look at element 2, count 1, the death was caused by the criminal act of Alicia Andrews. That always is going to be read in a principal case. She is never alleged to have touched a gun. She is never alleged to have been one of the shooters. She is guilty as a principal. And because she is a principal, you have to put her and treat her as if she had done all the things the other person or persons did if the state proved beyond a reasonable doubt she intended the crime to occur and that she did some act or said something that was intended to and did assist the other person or persons to actually commit the crime. That is read in conjunction with murder in the first degree, which this is a murder in the first degree. This is the highest crime, the top count that has been proven in this case. The second, the lesser to murder in the first degree is murder in the second degree. The principal instruction also applies to this. So when the defense attorney is up there arguing to you that Charles Jones is dead, obviously that has been proven beyond a reasonable doubt. The death was caused by the criminal act of Alicia Andrews. That the principal instruction also applies to that. So if you find that a lesser has been included, you don't say that she's not guilty just because she's not the person that committed the criminal act. The principal instruction applies to that. If you're looking at murder 2, that there was an unlawful killing of a victim by act imminently dangerous to another and demonstrating a depraved mind without regard for human life, and then it describes what the act includes. It also says in order to convict of second-degree murder, it's a distinction for first-degree murder. It is not necessary for the state to prove the defendant had any intent to cause death, but she can still be convicted as a principal. What separates second-degree murder from first-degree murder is premeditation. Premeditation, we've already gone over what that means. And in this case, there was premeditation. There was planning. There was getting weapons. All of that is a conscious intent, a reflection for a homicide to be committed. And that's what separates first degree from second degree murder. And with the judge's instructions, you will hear that you should find the defendant guilty for the highest count that has been proven beyond and to the exclusion of all reasonable doubt. And in this case, when you hunt and you stalk a victim in order to kill him, that is first degree premeditated murder. The defendant argued in his case that the defendant was cooperative and truthful to law enforcement. You heard all of that evidence, and we argue and submit to you that she may have said one or two truthful things, but the majority of what she told law enforcement was not true. You will see all of the messaging on the phone. You will see the conversations that she had with all of her friends. You saw the photographs. And here's another one, again, from her Apple iCloud that has been put into evidence. State 75C3 was not published, but we asked her specifically about Kay Shorty, another person in one of those photographs that you saw where that person is throwing gang signs. I'm not going to read all of it to you, but she's having a talk with him. And again, it is about more and more gang stuff. She is having a conversation with him, and if you look at this, it goes more and more about the death of Bibby and why he is so torn up about it. So this is state 75C3. Another person that we showed you a photograph that she is friends with that is in her phone. So look at all of the phone stuff and see that what she is saying when she suggests to you that she doesn't know what is going on simply is not true. She's not using a first name like Tom or Jeff. These conversations aren't about somebody named Ryan or Steve. These are names of gang members who have been killed in this gang war. You're going to see names like Bibby, Leaky. All of that is evidence of her knowledge of what is going on in Jacksonville and what is affecting the very people who she is dating, to such of effect that she has to delete messages from conversations that is over that they have had about it. That they have had about it. That is overwhelming evidence of her guilt. We ask you to take a look at all of the evidence in this case and hold her guilty and responsible for her own participation in this crime. She says she doesn't know Davian Murphy, and she don't know Rashad Murphy. She says that she cannot say to Davian Murphy, this big guy, that he shouldn't be smoking because she's pregnant. That's not what she says to law enforcement. In fact, and that's not even what she says on the stand. She's not saying that she's not giving their names because she's afraid of them. She's not saying she's not giving them their names because they're in a gang. She's saying she's not giving their names because she don't know them. She doesn't know he's in a gang, that she's not going to give any information on these people. And then in the same testimony on the stand, she is saying that she is afraid because they have not offered her any protection. Why does she need it? She didn't know anything happened. That's what she's telling you. She didn't know any crime had occurred. She didn't know Davian Murphy, doesn't know that he's connected to a gang, even though he's related to the person who was killed at Rains High School when she went there. She doesn't know that Rashad Murphy is in a gang. She don't know him. She don't know them. I don't know those people, right? And in the same breath, she is saying that nobody offered her protection. Did she look afraid in that interview? Did she look scared talking to law enforcement? Did she look intimidated talking to law enforcement? Or was she laughing? Was she bored? Was she annoyed? All of the evidence in this case show that the victim in this case was killed. All of the evidence in this case shows that the way that he was killed is first-degree premeditated murder. And the way it was done, it was planned, it was premeditated, and none of that can be done unless everybody talked about it and planned it and conspired together to do it. Based on all of the evidence in this case, we are confident that you will find her guilty of first-degree premeditated murder and guilty of conspiracy to commit first-degree premeditated murder.